Dwivedi?
No, 1904.
Then Justice Y.V. Chandrachud, my lords, 2068, para 2068.
And what is the principle which you are relying
They
on?
describe what is a constituent power. So the power which enables amendment of the provisions of the Constitution, be it a derived constitutional power, it is the nature is constituent. The fact that it vests in Parliament or it vests in the President being a head of the executive would not make a difference. The nature of power, it's certainly not similar to ordinance making power. Ordinance making power is specifically, expressly said to be having the force of the law made by Parliament. 123 and 213.
In fact, the ordinance making power would support your submission, because the fact that a power is not vested in Parliament, in this case the legislative power, the ordinance making power, is not dispositive of the nature of the power.
Yes.
It's not the institution which wields the power, but
That's
the nature
right.
of the power which is crucial.
That's right. I'm grateful. One has to consider the nature of the power, not who is wielding it.
So, for instance, one of the exceptions to the doctrine of separation of powers is the legislative power, which is vested in the Supreme Court to frame its own rules.
Yes.
It's also regarded as legislative in character.
It is. And it is original, flowing from the Constitution, not otherwise.
Likewise, Parliament has the power to punish for contempt of itself.
Yes.
So that is, in that sense, not a legislative power. It's a judicial power which is wielded by Parliament. So according to you,
there is no absolute
370 itself is a constituent power.
Yes.
Because it's a power to amend the application of the Constitution to Jammu and Kashmir.
That's my answer. Then was it, with regard, the other submission which I made was about recommendation. I will not repeat that why, my lord, recommendation should be considered as non-binding, but just to compare, my lords, Chief Justice had last occasion words. If your lordship looks at article money bill, of course, the lordship saw, my lord, but that's different, my lord. That goes to Rajya Sabha. They expressly mentioned that Lok Sabha is not bound.
Yes.
So money bill provisions are 109 and 198. Then there is a disqualification provisions, that is article 101 and 192. Now please see 101. Though the word is not recommendation, the word is opinion. If there is an issue of disqualification, I'm sorry, not 101, 103, lords. 103. I apologize. 103. One makes the decision of president final, but 2 says before giving any decision, I'm drawing my lord's attention to 2. Before giving any decision on such question, the president shall obtain the opinion of the election commission and shall act according to such opinion. Mark this last expression. So where they want that, my lord, if some other body, whether inferior or at par or superior, is not material, but of course it is disqualification and a decision given by the election commission. But they wanted that the president should have no other discretion left. He has to act. Now these words are not deployed in 373. Now similarly, when we come to finance bill, that is article 117 and 207. 207 is for the state. Sub-article 1 of 117 A bill or amendment making provision for any matter specified in clause A to F of clause 1 of article 110 shall not be introduced or moved except on the recommendation of the president, and a bill making such provision shall not be introduced in the Council of States. Now, this is a perpetual provision, it was not a temporary one. And the proviso says, provided that no recommendation shall be required under this clause for moving of amendment making provision for the reduction or abolition. Now, Millers, very interestingly, the bill is to be placed by the cabinet, the Council of Ministers. And the recommendation is to be made by the president, which is also Council of Ministers. Now, this is relevant for Article 3. So our framers do contemplate situations where the Council of Ministers is at both the ends. At one end, it speaks through the president. At the other end, it's the framer of the bill and places it before the House.
And President is acting on the advice.
Advice was, in a way, it may appear to be superfluous because if the cabinet has to place it, straightaway proceed because the cabinet and president in any case has to sign it and recommend. But the situations are different. Similarly, 117(3). A bill which, if enacted and brought into operation, would involve expenditure from consolidated funds shall not be passed by either house unless the president has recommended to that.
The reason why it was said that the president must recommend and not the council, so that's really what it means.
Yes.
Is because under Article 84, the parliament consists of the president and the two houses of parliament.
Yes, yes.
The parliament doesn't consist of the council of ministers because the council of ministers are all members of parliament.
That's right.
But the president is a part of parliament.
But all bills don't go through the president.
They don't. Only money bills.
Only money bills. So, sort of, perhaps it was intended to be an additional precaution that the president may look into it, may perhaps exercise his power under Article 75, etc., to divert it. And
so you don't specify the council of ministers because they are part of parliament. Individually, they are members of parliament.
Absolutely. Correct.
So recommendation you have shown us 109.
Now kindly see 146(2). Now this is a case, my lords, which my lords were referring about the rules power of the court.
Yes.
Now this is not from a superior to an inferior or something else. Here the approval is required because of financial implications. (146)(2), and for High Court it is 229(2). Subject to the provisions of any law made by Parliament, the conditions of service of officers and servants of Supreme Court shall be such as may be prescribed by rules made by the Chief Justice of India or by some other judge or officer of the court authorized by the Chief Justice of India to make rules for that purpose. Provided that the rules made under this clause shall, so far as they relate to salaries, etc., require the approval of the President. It can never be argued, my lord, that if this, supposing this proviso is deleted by the root of 368 to ensure greater independence in financial matters, will the main part die, my lords? Are they rolled into one?
Yes.
So the fact that the proviso ceases, the main part ceases, and one very great argument, my lord, Mr. Gopal Shankar Narayan had raised, drawing my lord's attention to the colon. In 373 also it exists, perhaps to suggest that they are rolled because there is a colon, therefore they are rolled into one. every proviso in the Constitution of India, I have gone through, Lord, there are several provisos in various articles. All of them, Lord, have a colon. And colon in grammatically indicates only an addition, nothing more. Lord. Every proviso, Your Lordship may see. In fact, in 146(1) itself, there is a proviso, colon. Nowhere Your Lordship will find any other, a full stop or a comma or a semicolon. It's always colon. Because it addition. Generally, as a rider, the rider goes, the main part expands. So if the proviso goes, Lord, in 146(2), then the main part, the power of this court, Lord, will expand, no need for approval. And the last part of this section of my submission is that so far as Parliament is concerned, the CO 273 does not refer to 367, etc., or 356. It only says exercising the power under 373 and acts on the recommendation of Parliament. Now, Parliament, Lord, can come through the route which the Union adopted. That's one part. My learned Solicitor General has already submitted. I will not repeat at all, Lord, on that. I adopt that, Lord, and nothing which I say detracts from that submission. But an additional submission is, Lord, that the President means Council of Minister, and Council of Minister means collectively responsible to the Parliament. So, Article 53 read with 73 and read with 75(3). Say, my Lord, Council of Ministers can go to the Parliament any time for its obtaining its views. So the fact that Parliament's recommendation has been obtained, Parliament is not a foreign body. And the parliamentary rules, Lord, any issue can be brought before the Parliament, resolutions can be passed, the views can be obtained. So we need not go, Lord, in my referral submission, of course, that stands. But irrespective of that, independently of that, the obtaining of the recommendation is not foreign, Lord, to the exercise of power under 373. Because of these three provisions taken together. So
can you reformulate that?
The submission is that Parliament's opinion, recommendation or views for exercise of power under 370 sub-article 3 can be obtained by the Council of Ministers on account of the provisions of Article 53, 73 and 75 sub-article 3. Since Council of Ministers is responsible to the Parliament, so it can always go to the Parliament. In fact, that's the best route to go to the Parliament because it's a big decision being taken. So the whole of Parliament is being taken into confidence. Instead of rushing through in an executive forum alone, there the voice taken together, both the houses, the voice of the people of the whole country is heard, including the member of parliaments of Kashmir, who are also represented in the Council of States. So therefore, CO 273 is sustainable on its own. And one small aspect, Lords. Let's take the submission of the petitioners at the highest, Lords. What are they trying for, Lords? This permanence which they are seeking is for what? According to them, Lord, Sampath Prakash, sub-article 2 is already defunct. According to petitioner's submission, main part proviso rolled into one, therefore all of 3 is defunct. A, of course, 238 itself has gone, is defunct. B1, Only, my lord, and B1 has a very narrow scope, lords. Please have B1 once again. I have a slightly different take on B1. B1 is not for determining the matters irrespective of the list. What matters have been specified in the instrument of accession are to be determined by a reading of the instrument of accession itself. Nothing can be taken away from that. That is final, sealed. What B1 is limited to discovering which of the entries are corresponding to those matters. There are matters specified in the IOA. There are matters specified in the three lists, which are corresponding. It only discovers the entries. There is no power at all to vested in the president to act in consultation to detract from the IO surrender. If defense is been surrendered, then it has to be exercised as per Constitution of India, wherever the power is. Only the entries has to be located. And that power cannot be controlled. You take away residuary power or do whatever. Subject matter of defense is surrendered by that, and therefore the central union government will exercise full powers with regard to communications, etc. Entry or no entry.
Because there may be more than one entry
Yes.
in the union list or concurrent list, which corresponds to a head in the instrument of accession.
That's right.
The instrument of accession was prepared at a time when the constitution was yet to be framed.
Yet to be framed.
Therefore, it used broad expressions: defense, external affairs, communications, and it had various subheads, as we saw yesterday. You showed us that.
Yes.
For instance, defense. Now, just take one example only. Defense.
Yes.
In the union list covers entry 1, defense of India; entry 2, naval, military, and air forces; 3, 2A, deployment of any armed force, which came in the 42nd Amendment;
And
4,
arms.
naval, military, and air force works; 5, arms, firearms, ammunition, and explosives. Yes. So it was basically what the president had to do was look at the entries in the lists and see which of these entries corresponds to what the IOA has said would be the domain, of the Dominion of India.
And consultation came in for a reason, historical reason, because when cabinet mission plan was being considered, then primarily Nehru ji and the Congress itself wanted to keep it loose. And they were all the time contending that these expressions are only categories of entries, matters. It's not one matter, defense. There's a whole lot of other things. For if you want a defense, you will need finances for the defense. So he was interested in expanding and centralizing. More power to the center. So there was one thing that therefore you consult, get their views. It's okay. So consultation is a weak expression, it doesn't bind the president at all. However, that's the difference which I pointed out, that this is only to discover the correspondence. But it cannot detract from the surrender in the IOA. Now, since that has been done, this is also defunct.
Just 1 minute.
So what survives is B2 and D, proviso 2. Even the first proviso, correspondence.
Is what survives according to you is B2.
And D, proviso 2. I'm taking the case of petitioners, not according to me, but
No.
according to them.
You're testing their hypothesis.
Yes, we have to test, Lord, what is it you are gaining, Lord? What are you wanting, aiming at? You seek permanence for B2 and D, P2, proviso 2.
Sorry, just come again. B2 and D, proviso 2.
Yes. And Lord, over the course of years, almost all institutions of the union have been applied. Very little remains in B2 and D2. So permanence for that. It really leads to the principle, Lord, that we should avoid absurdity, Lord. It's a reductio ad absurdum, Lord. Lord, the second vital question which arises with regard to 370 is, what is the status of the Jammu Kashmir Constituent Assembly and the Constitution of Jammu Kashmir? If I may use JKCA and COJK. And there are two contending thoughts. Once again, the choice is between these two.
Yes.
We are saying that the source for creation and disappearance of the JKCA and the COJK, Constitution of Jammu Kashmir, is Article 370 itself. Whereas the petitioners contend that the source for these two bodies flows from the crown of Hari Singh. That is to say, residuary sovereignty, remnant sovereignty, or internal sovereignty. Three expressions have been used by three different councils.
What are the expressions?
Residuary sovereignty, remnant sovereignty, or internal sovereignty.
Shared sovereignty.
Shared, which my friend Nitya Lord used, has a different connotation. We are all sharing, Lord. We are all co-sharers of sovereignty. Every individual citizen is a co-sharer. I have no problem with sharing of sovereignty.
Residuary sovereignty.
We all share, Lord.
Remnant sovereignty, and the third?
Internal sovereignty.
Internal, yes. Mr. Dr. Dhawan said that.
And from this idea of remaining balanced sovereignty, there was a further, Lord, concept introduced, bilateralism or compact. There are two sovereigns now, one remnant and one the main sovereign. So the two sovereigns are talking to each other, whispering to each other, and all that theory, Lord, and compact and bilateralism emerges. So the choice is between these two, Lords. If you accept that some sovereignty remained after the signing of the IOA, and some sovereignty remained after agreeing proclamation, Lord, that of Yuvraj Singh, that relationship between union and the state will be defined by the Constitution of India as applicable to. Then that expression is very important. You don't have to go out of Constitution of India. It is defined by the Constitution of India as applicable. Whatever it may be applicable, but it is to be found within the terra firma of the Constitution of India. This methodology, my lords, just let us have a look, my lord, what is the Constitution of India telling them? Note two things, lords, which are expressly in 370 first. The first is the explanation. And the explanation applies to the whole of the article, not only sub-article 1. In terms, it says, for the purpose of this article, the government of the state means so and so. What is it doing, lords? One, it is substituting the Maharaj for Maharaj acting on the advice of Council of Ministers. So the monarchy is dead. The popular rule came, my lord, when the Maharaj, my lord, came, my lord, when he was neck deep in trouble on 25th of October 1946, when the war was there, everything was virtually being lost. He had virtually nothing left for sovereignty, my lord. And it is on that crown, my lord, which they are, the sinking crown on which the petitioners' submissions are banking. However, that crown also, my lord, Nehruji first said that you release Sheikh Abdullah and popular government. He was released, he was made the Prime Minister, and on his advice, it was not simply Hari Singh, it was both the popular government and Hari Singh, Lord, who agreed to the accession. So the people's voice was also there. And the explanation leaves no room of doubt that the Maharaj is not to act on his own view, opinion, discretion, but act on the advice of Council of Ministers for the time being in office. Second, my lord, even the Maharaj has to be recognized, that person who is recognized by the President of India. So when Yuvraj, my lord, issues the third proclamation in 1951, that is after the Constitution of India came into force, he was acting on the advice of the popular government in terms of the explanation to convene, to constitute and convene the JK Constituent Assembly. The next question would be, my lord, what is it? For what purpose are you constituting? And the purpose is spelled out by sub-article 2. So the Constitution envisages that this assembly is for the purpose of framing the constitution of the state. The third thing, my lord, is in framing of the constitution, the JKCA is does not enjoy the freedom which the Constituent Assembly of India had. It was bound by several things. First, it was bound to frame the constitution in a manner that the sovereign democratic Republic of India, that's not adversely impacted. And at the moment, I'm not relying upon the doctrine of basic structure, which came later. But even as it stood in 1950, 26th of January, this constitution of JKCA could not detract from it and has not. It had to ensure justice, liberty, equality, fraternity. The contours of lawmaking are specified on account of the sheer accession. It was also bound by Article 1. It could not declare that we are not the federal unit of India. And it accepts in that dictat of the Constitution of India in Section 3. That's not their own framing. They are bound to do it. Next, my lord. They could not therefore say that any part of their territory will not form part of the union territory. That is 1(3). They could not also say that every person domiciled in the territory of India, and your lordships have held, my lord, I'll give that judgment where lordship said there's only one domicile. Every state does not have a domicile. Nobody can say I'm domiciled in UP or Tamil Nadu or Bihar, etc. So they could not say that the people who are, that is the permanent residents of Jammu and Kashmir, will not be the citizen. And they accept that, my lord, in Section 5. That's not a gift of JKCA. That's the gift of the Constitution of India and the dictation of the Constitution of India to them. The same applies to the fundamental rights. Every citizen, see the concatenation and the connection between these provisions. 1, 5, Part 3, which says every citizen. In fact, some of the fundamental rights are broader, but 19 specifically citizens. So these rights could not be denied, and therefore they rightly will not follow it, the diktat will not, and put it in Section 10. Even if it was not there, my lord, they would have enjoyed these fundamental rights under the Constitution. And neither the president acting, my lord, under 370, nor the authorities, my lord, who are giving concurrence or consultation or recommendation could say that apply 370. That's not the purpose of the recommendation, is very narrow. Continue operation, don't operate, or operate with some little modification. So therefore, my lords, these fundamental rights, etc., and they also could not say, and they have wrongly not gone into that in my humble submission, when they said that Article 136 initially of the Supreme Court's power will not apply to Supreme Court. They could not say that. Because in the accession, my lord, they have said, we accept the Governor General, which will be President now, the federal legislature, that is the Parliament, the federal court, that is the Supreme Court, and other authorities, my lords, who are under the Constitution charged with certain functions. The power to fix terms does not mean, my lord, that you take away the power of these authorities under the Constitution. But things have been happening, my lord. 35A has also come, 136 had gone. That to deprive 136 to the people of Jammu Kashmir, my lord, is a huge denial to them. So in short, my lords, the framework of the Constitution of India, and when we look at JKCA, we find that the entire JKCA is a reflection, my lord. There's nothing peculiar in that, my lord. What is peculiar is 147 when it says that you can't amend the constitution. My lord. There are restrictions. Likewise, section 5 says that whatever be the parliament's power under the Constitution of India. So throughout it follows the diktat and respects the Constitution of India, and there is very little in it which is different. This methodology which has been adopted by the Constitution of India for the formation of JKCA, its convening and its enforcement, in my humble submission, is very akin to the juristic concept of devolution of powers. Devolution of powers. The Constitution has devolved power on the Yuvraj, then acting on the advice of Council of Ministers, to convene for the purpose of framing the Constitution in accordance with the broad format, as I pointed out. It's not an independent power like the Constitution Assembly of India. I'll give to your lordships, in view of the time constraint and these two judgments. This concept is frequently applied, Lord, in United Kingdom. Scotland, Northern Ireland, Wales, all of them are enjoying devolved powers. The Parliament of UK is considered to be supreme. There, of course, that is somewhat different in the sense that the law made by UK Parliament for Scotland specifies not their Parliament. So we have Scotland Parliament also, Northern Ireland Parliament also, and the Wales Parliament also. So it doesn't matter that you call your person Sadar-e Riyasat or Prime Minister or Chief Minister, the stature doesn't expand by these expressions. The stature will depend upon the nature of power you are exercising. It doesn't equate with the power of Prime Minister of India, even if you call them Prime Minister. Yeah, psychological and emotional reasons apart. So the two cases, my lord, they are not on record, so I will not place it, my lord. The time bar is there. I'll just give the reference and paragraphs through your lordship, my lord. I will not admit him. We did send it, my lord, but it's not admitted, so it's up to your lordship.
What are the two cases? You can give us a citation.
I am giving the citation. 2002, Volume 1.
What's the name of it?
The name of the party is In Re Scottish Independence Referendum Bill. In Re Scottish Independence Reference Bill 2022, I'm sorry, 2022, yes. UK SC 31.
You repeat the citation again?
Paragraph.
Please repeat the citation, Mr. Nehru.
2022
Yeah.
UK SC page 31. Para 76, 77, 82, 88 and 90.
Yes.
And how can you just sort of summarize in a sentence what the principle is?
The principle was, my lord, that in this case, they wanted a second referendum. Sorry, my lord, when the Brexit was happening, then they wanted to continue relations with Brexit. So it was impinging upon the sovereignty of the parliament, my lords. In that context, my lord, they have discussed this devolved powers. And they say that the parliament gives the power and parliament can take the power, it can modify the power. So the parliament is So this power is also a devolved power of a different kind, of course, because it's more general. It's not itself framing like other states what they are to do. They don't have the list too. So it's a little more. So that's the departure. So you have the psychological satisfaction of.
And what is the second judgment?
Then the other is 2000. This is case is UK withdrawal from European Union. 2019, 2018, UK SC.
2019 or 18, you said?
18,
Yes.
UK SC, page 64. Paragraph 12, 13, 29, 53, 61 and 63. Now in this context, Lords, kindly just keep my written submission open, Lords. It's in the combined. I have tried to extract things there, Lords, so that I don't have to request your Lordships to open the document as far as possible, Lord. The other aspect, Nehruji himself says that the idea of having a constituent assembly for framing a constitution for the state emanated from the government of India. And that is, your Lordship will find in para 128, page 44 of my submission.
It's in which volume?
This the combined compilation, volume 3 written submission.
Volume 3 is Mr. Solicitor's, no? Mr. Tushar Mehta's, right?
All
It's in that.
submissions are there.
Oh, I see.
All submissions are there only.
Right, but that's in volume 4. We got it. Yes, we got it.
It starts at page 271. Oh, so
Volume?
Kindly come to the last 8 lines, notes.
Of which page?
It will be, notes, paragraph 128 at page, PDF might be 44 minutes.
Not 44.
Para 128,
Of your submissions?
submission.
Where do your submission start from? Which page?
They start at page 271.
Yes, it
What's
starts
your
from
internal page?
271,
What's your internal page?
page 44.
That will be about 313, I guess.
PDF 316,
what's the paragraph number?
128.
Yes, it's page 316.
Okay, hold on to it.
If towards the middle, you shall find, thus the monarchical power had disappeared. Lordships have got this one? Hello, Justice
Yes.
Surikant.
Yes,
One second. What page is it?
Hello, Justice Gawai has got this?
Yes, para 128.
Yes, Lord. I'm grateful.
Judgment? Para 128 is from a judgment, it appears.
No.
It says Sri Nafri Learned Senior Counsel.
That was, we are responding to the submission of Mr. Nafri.
Oh, all right.
They were all saying, Lord, that the Maharaj has found how he will form the JKCA and
Let's quickly go through that.
Lordship may have the middle, Lord, only.
Yes.
Thus, the monarchical power had disappeared with the advent of the Constitution of India. Maharaj Karan Singh merely.
Just one second.
I'm so sorry.
Monarchical power.
Yes. Thus, the monarchical power had disappeared with the advent of the Constitution of India. Maharaj Karan Singh merely executed the mandate of the Constitution of India embodied in Article 370. Secondly, speaking in the Lok Sabha on 26th of June 1952, soon after the proclamation of Maharaj Karan Singh dated 1/5/1951, Prime Minister Shri Jawaharlal Nehru said, "So the government of India and others put it to them to the Maharaj and Sheikh Abdullah as soon as he came out that this matter must not be hurried, and it was our idea then that a constituent assembly should be elected in Kashmir quickly and as soon as possible to decide about these and other questions. So we advised them. So in view of 370, and perhaps not because of the international situation regarding Kashmir which was developing, the government of India wanted that it should be convened, there should be a ratification of accession and all that. That's the idea came from here, not coming from them, my lords. What was Maharaj Hari Singh wanting, my lords? He contemplated a national assembly. He was still dreaming of independence. So he was thinking that when the whole of the POK, etc. comes in, then there will be plebiscite and then we will decide whether to accede or not. And that's the mischief which Mountbatten played when he wrote a reply letter when he said that our policy of our government is, who is he to write, my lords? He is bound by the Government of India Act and the adaptation order, which says that once the Governor General accepts the accession is complete. And Indian armed forces are there driving back the people who had come inside to grab Kashmir. But he writes a letter, my lords. Governor General directly writing a letter. Policy of our government is that letter has no meaning. Mr. Sibal referred to that letter to draw some sovereignty, my lord, etc. That still looks sovereignty remained. Accession was still a dispute, still to be settled. It's not final. So where are we to go? To what extent, police? So what Hari Singh contemplated was completely different. What Karan Singh proclaimed was our relation will be defined by the Constitution of India as applicable to you. The two different contrasting expressions used there.
What remains, Mr. Vedi?
Because a lot remains. Because we will, sum total, we will not be crossing the boundaries, but these aspects need to be placed before our lordships and have not been placed. Now, my lords, the question is, what did they refer to? Mr. Sibal started from the cabinet mission plan, return of paramountcy. Then, when the British left, all Indian states became independent. They were free, my lords. Many felt so. From there, my lord, the sovereignty element is being derived. What is forgotten is that cabinet mission plan was again a British device to frame a larger Pakistan within India. Three groups. The central provinces, Group A. Northwest, Group B. Assam and Bengal, whole of it, Group C. Something which even Muslim League did not demand, the British were framing. Because they wanted a lot to control the two frontiers for geopolitical reasons. They want bases at both the ends. So they came with this cabinet mission plan. And it was basis was that parties are not agreeing, therefore we are presenting arbitrators. And what was the dispute? Well, the first great interpretative exercise where the fight was, are these group frozen? They provided an expression that once each group will frame a constitution, and once the constitution is framed, then the provinces which are part of the group may decide to remain or to go out of the group. Then the leaders who were leading on the side of the Congress, they said, no, these groups you may form, but once it is formed, then the provinces need not wait. And they will, so the huge fight not about the frozen character of the groups. And the other issue was parity at the center, weak center and parity. Parity, Congress, Muslim League, and the princes, three. So who controls blood? as we say in the Bandarbat Mullahs, the British becomes the arbitrator. There will be stalemates on every issue. Now this creates a larger Pakistan. The option was partition. Now this went on. Our Constituent Assembly was constituted under the plan. So we decided to work out the plan, but without being bound by the Cabinet Mission plan. And it was made very clear by our leaders that once Constituent Assembly starts, then what it decides is not your concern. It may choose to destroy the groups also. In fact, the leaders were called to London also, and they said it may be referred to federal court in case of dispute, but it will, our acceptance will remain qualified. Now 26th, 9th of December, 1946, our Constituent Assembly started functioning. Temporary chairman, Dr. Rajendra Prasad, again, objective resolution placed on 13th of December, debated, accepted and adopted on 22nd January 1947. All this is happening before 15th of August. Then they proceed to form a negotiating committee to negotiate with the states and based on the Cabinet Mission plan which the princes had accepted. Please note Section 8 of the India Independence Act recognizes that the Constituent Assembly of India is that which began functioning on 9th of December 1946. There may have been a withdrawal of the British legally and physically on the 15th of August, which we celebrate as our Independence Day. But our independence is not a grant of India Independence Act. It is a result of the long drawn people's struggle. That's why the We the People has come. There are some observations in Justice Beg's judgment, Lord, in Indira Gandhi's case, which the other side relied, but I found some other observations which say that independence was granted by the India Independence Act. India Independence Act, what does it do? There shall be two dominions. It is partitioning and providing an interregnum arrangement what will happen in between. Namely, the Government of India Act continues with adaptation, etc. And that the Constituent Assembly will also function as the Legislative Assembly. That is also provided in. So it's a machinery act, a transition act. It's not an act which grants us. They say dominion. Somewhere, my lord, expressions of dominion are still lingering in our constitution. My lord, the Attorney General and the Solicitor should take care that they are deleted. There are some provisions where still, my lord, the word dominion continues. But we did not accept the dominion. Here comes the role, my lord, of the objective resolution. It said we are adopting an independent democratic republic. So the negotiation with the Indian states are based on the concept of republic. And since our assembly continues based on that objective resolution from 9th of December 1946, therefore, this republican character is the basis for accession. This is important for the reason, if you compare Section 5 and 6 of the Government of India Act 1935, it talks of a different kind of federalism, a federalism under the imperialism, a federalism under the crown, and a federalism which will be triggered by the decision of His Majesty. Provided more than half almost of the princes agree then to come in. So a different kind, accession, signing of the instrument of accession under the Government of India Act is different from signing of the instrument of accession under the Constitution of India in the making or under the Government of India Act as adapted. My lord said, notice the expression union, unity. There is some very vital document, now my lord, government has released several volumes of transfer of power, having about total of 13,000 pages. I was able to get this document, which is annexed to my written submission. Kindly have a look at that. It completely changes, and all these documents were not present, my lord, in the earlier exercise relating to 370. PDF paper. PDF page 327. Lordship has this?
Yes.
My Lord Justice Call has this?
This volume 11, the Mountbatten. Is that what you're reading in extra 2?
No, I'm on the same written submission, Lord, which I was reading
Yes,
earlier.
Yes, yes.
That's the trans-
327 begins with
Volume
the
3.
Constitutional relations between Britain and India.
Yes, yes. May I please it? My Lord the Chief Justice,
Yes.
please read below the caption, section 5 of the Act. A revised draft.
Where do the page 327 is the title page.
Next page, Lord. Page,
Next,
running page 70.
that is 8 June 1947.
The letter of 8th June
Mr.
1940.
Rajgopalacharya to Sir S.
No, Lordship, go ahead. I'll come to that letter later, my lords. Please come to running page 73. Oh,
Where is Mr. Kanu Agarwal?
Sorry, PDF 334.
PDF
334. I'm so sorry.
334.
Achha. All right, got it.
334 is a part of some document, I guess. What is that document that this is a part of?
Oh, that's some earlier
It's
letter, my lord.
enclosure number 1 to number 111. The disappearance of paramountcy, the emergence of independent sovereign states, and the balkanization of India by Sir Allah.
PDF 345.
345. 1 second. Give us a moment.
Three, four, five meetings of the Indian cabinet.
Yes, meeting of the Indian cabinet. I'm grateful. May I place that, please? Meeting of the Indian cabinet.
Yes, 345. Actually, this is a part of volume 12 of the transfer of transfer of power documents. And now we have
Oh, hell, you be told.
page 345, which is meeting of the Indian cabinet,
That's right. May I place it?
Mountbatten Papers, Indian Cabinet Minutes, Part 2.
Yeah, the Indian Provincial Constitution Order 1947 was being discussed. The Honorable the Vice President recalled that in the discussions at the previous meeting of the Cabinet on the India Provisional Constitution Order 1947, two sections, namely Section 5 and 47, had been left over for further consideration. Section 5. A revised draft attached, prepared by the Reforms Secretariat in the light of the previous week's discussions in the Cabinet, was handed to the honorable members. It was pointed out that there was the same fundamental objection to the draft as now revised as to the originally redrafted Section 5 of the Act considered at the previous meeting. The draft gave the impression that the dominion was limited to British India, which was an entirely wrong conception. it was necessary to devise a formula to show clearly that the dominion of India would comprise A. Governors' provinces, B. Chief Commissioners' provinces, C. Such Indian states as acceded to the dominion, and D. Any other areas which by consent of the dominion would be included in the territory of the dominion. Now this is important. Political and psychological considerations demanded that there should not be the least doubt that all states that acceded to the dominion would form an integral part of the dominion. This is how, my lord, the reason for changing, my lord, the earlier draft and, my lord, section 5 and 6 of the Government of India Act. So, my lord, the cabinet of the Government of India, which had resolved already to form a republic, independent sovereign republic, is saying that the moment you accede, you become integral part of India. Now, the whole thing changes a lot with this backdrop. If you read the IOA, which was signed, it was a formatted document. Everybody signed. So all those mergers and etc., which are being talked about, is neither here nor there. They are just a methodology. Mergers are generally happening a lot of small states to the next door state or union of state which they formed. That has nothing to do with. Now, some states have accepted the Constitution of India, some may not have said so. That's once you sign, that's the last. You become integral part of India. With this adaptation order before the Indian states, the rulers signed the instrument of accession. So therefore, every state which signed, so far as it's becoming an integral part of India. And in fairness, Mr. Sibal concedes not that JK is fully integral from that point of time. But it has consequences. So when Article 1 talks about merger of territory, when it talks about including the state, it is not just off the cuff. That's the mandate flowing from the statute, accepted by everybody. Everybody is acceding on that basis. So it's an understanding. Therefore, all these states are mentioned in the schedule and their territory is incorporated. That's the integrity. And the instrument is at page yes. That is at PDF 350, which your lordships have seen in the other volumes. Lordship may just note that in the very beginning it says, Dominion of India established by the India Independence Act shall, as from 15th August, be a union of, that's the first clause is the amended draft. Section 5. And please see C, 5C, Indian states acceding to the dominion in the manner hereinafter provided. So if you accede in the manner under section 6, you become part of the union. This is also there in volume 6, PDF 103. And 6A says, if you declare that he accedes to the dominion with the intent that the Governor General, Dominion Legislature, Federal Court, other dominion authorities established for the purpose of dominion shall, by virtue of instrument, but subject to the terms thereof, and for the purpose of the dominion, be vested in the order under this act. So once you accept all these authorities, once you integrate, how do you integrate if you don't accept? And the terms, the expression subject to terms doesn't mean that you, these are minor modifications or qualifications which may come in, but you can't say that on the one hand that I accept the Supreme Court, I accept the President, I accept everything, but qualification, I will not accept 136. So therefore, my lords, my submission is that our independence is not a grant of India Independence Act. We had already resolved to form a republic, a sovereign independent republic. And 3, we amended the adaptation orders to make it clear to all the rulers of the states that the moment you sign the instrument, you are part of the union, you are integral. So,
Actually, if you see the constitution, the provisional constitution order of 1947,
yes,
which is a part of Mr. Arvind Datar's second edition of 2007,
yes, I
you'll
will
find it here at page 348. Page 348.
Yes, Manoj.
And what it says is that, the Government of India Act shall apply with such modifications as are specified in the schedule.
Yes.
Right? And if you go to the schedule now at page 350,
Yes,
there you will find the modification of section 5.
that's right.
The Dominion of India established by the Indian Independence Act shall, as from the 15th of August 1947, be a union comprising of C, the Indian states acceding to the Dominion in the manner hereinafter provided.
That expression is very important, in the manner.
In the manner. And now 6 says accession of Indian states.
Yes.
An Indian state shall be deemed to have acceded to the dominion of the governor if the Governor General has signified his acceptance of an instrument of accession executed by the ruler, whereby the ruler on behalf of the state A declares that he accedes to the dominion with the intent that the Governor General, the Dominion Legislature, the Federal Court,
Yes.
and any other dominion authority established for the purpose of the dominion shall, by virtue of this instrument of accession, but subject always to the terms thereof, and for the purposes only of the dominion, exercise in relation to such states such functions as may be vested in them by or under the Act. Assumes the obligation of ensuring that due effect is given within the state to the provisions of this Act, so far as they are applicable therein by virtue of the instrument of accession.
Now, B completely destroys the argument of internal sovereignty. You have to give effect to all these authorities, the laws made, the execution done, the judgments given within the state. Reservation of some subjects doesn't mean that some sovereignty remains. That's a distribution of powers only. So you have some more powers which others.
So what do you make out of that statement in the IOA where the Maharaja said that I have retained my sovereignty for the future?
You see, section 6, which is amended, does not contain any such term. Maharajas cannot, as the learned Solicitor General showed, somebody is saying that we will have reservation about tax. So that's their wish. You may wish anything. But so far as the statute is concerned, as adapted, section 6 does not contain any clause 8. All that remains is that by supplementary instruments, you can further make more concessions. You may concede more subject matters. That clause 8 is completely beyond 6. It has no validity. But I will say, you read that clause 8 of IOA where Hari Singh says, I preserve my sovereignty. That is only meaning that he is preserving his power to legislate and do whatever with respect to the remaining subject matters.
Right. What's the next point, Mr. Dwivedi? We'll have to leave some time today for Mr. Giri. So long as all of you are within the time framework, we have no problem.
But our time should be up till Monday, at least.
Monday afternoon, Monday lunch.
So
That
we'll
is-
try to finish by that. It won't.
Monday lunch is the final time.
Ordinary may not be a spill at all, Milords, but
We were hoping that
the
we'll
learned
complete
council
today, but,
have
it's quite-
agreed, Milord, that I must.
Monday afternoon we have to, so that then we can give them the rest of Monday and Tuesday to complete the rejoinder.
We'll. So we'll, as I said, no, we'll try to.
Mr. Dwivedi, can we do this? We are 12:05. We can give you 10 more minutes. And then Mr. Giri, 45 minutes till through lunch and we wrap
So
up.
we'll finish by 12 Milords, instead of stopping Milords, Mr. Giri, you know.
No, but
We'll finish.
Primarily now, the main council are to follow you, Mr. Giri, Mr. Mahesh Jetmanani and Guru. Right?
So we'll
The others, look, one second, don't interrupt. I'm in charge of the proceedings. We have to, these are the three seniors. Now, after this, we'll have a lot of interveners, etc. But what is to be said has been pretty much said. We will request all the interveners to please talk to the council who are following you, following Mr. Datar. Whatever they have to say, they may indicate to the council who are now going to argue, so that the four council will cover the entire gamut. I think that would be a very fair way of doing it, and then we'll hear the interveners for 2 minutes or 3 minutes.
That's
all. So please, 1 second. This is now a procedural. This is a procedural mandate now, which is that all interveners who are going to follow will talk to Mr. Giri, Mr. Jetmalani, and Mr. Guru. And whatever you have to say, please tell them to say it on your behalf. They will not be charging a separate set of fees, and we will conclude with that. I think that's the only way. Now, tell us, Mr. Dwivedi, how long now?
We'll finish, our side will finish by lunch, Milord. The Lordship is, because otherwise, Milords,
All right. Do we take that, that between Mr. Giri, Mr. Jetmalani, and Guru, you have bifurcated the time with Mr. Dwivedi? Do we take it so that you are finishing by lunch on Monday?
On Monday.
Yes. So,
Just that.
whatever remains, 1 second, whatever remains after Mr. Jetmalani, Mr. Giri, and Mr. Guru Krishna Kumar have completed, we are here to hear you until lunch, but we will not hear the respondents after lunch.
Request and do implement application on behalf of.
Fair enough. We have no difficulty. After we've given you the names of people who are going to argue. After they have finished, if there's some time remaining before lunch on Monday, we will hear you certainly. But after lunch, that's it. At 2 o'clock, we call upon Mr. Sibbal to start the retirement. Oh, I'm so sorry. Nothing now. We have to now. We'll have the whole country wanting to argue here, but now that's all right. That's all right. Good. You sit with the seniors who are arguing after. There has to be some order. You can sit with the seniors during the course of the weekend, and you can talk to them. If somebody has a point, please tell them. Yes,
let me.
Adhering to what your lordships have indicated.
absolutely.
Right.
Can the interveners circulate a short note?
No difficulty. Absolutely. A page at the most.
Because,
Lord, some of them have taken a lot of, invested a lot of time, passion.
But of course, we don't deny that. But then presentation has to be through either the seniors who are arguing have to curb themselves, or then we have to just do what we have to do.
We'll abide by the timelines that your
Yes.
lordships have indicated.
kindly just note the documents. I will not read, not because of the time constraint. Your Lordship may look into it. Just at PDF 328. This is about the paramountcy. What was the view of the leaders on the Indian side when they were discussing? None of these Indian states were independent, really.
Mr. Dwivedi, we have understood this argument.
Yes, I'm not reading therefore. I'm just saying, Lord, Your Lordship may note the first is Rajagopalacharya's note. The second note, Lord, is at page PDF 331, which is Sri Alladi Krishna Swami Iyer, Lord. And they took lot of pains And the last note is of Pandit Nehru himself, my lords, at 339 to Lord Ismay, who was the chief of staff of Mountbatten. All three of them, my lords, they were persisting that they have never been independent. What are you doing? This return of this paramountcy was an attempt to balkanize India, create so many enclaves, and that created so much problem. And it is thanks to Sardar Patel's Lord that all this was quick. And when he left, he was wondering, my lord, that what he was trying to negotiate on three subjects. And Sardar Patel, he said that you have wiped out the monarchy from the map of India. So therefore, my lord, they were hardly independent. And we know from Amritsar Treaty, my lord, on the basis of an amount of money and 1 horse and 12 shawls, etc., which is mentioned in the next document, I will not read it. It was transferred to Gulab Singh, and that's how this. So when were they earlier under Ranjit Singh and some king or the other? They were never independent. So that's the. So therefore, this sovereignty flowing internal residuary, whatever, there was no sovereignty. And whatever left, Article 1 finishes. That's the complete merger. No merger agreement is required. No supplementary instrument of accession is required. Now, my lords, in Re Berubari, kindly read, I am reading only from this note, para 73 of my written submission, which is at page 298. Has it?
Yes.
Now kindly come to PDF 299. The bold portion. Cession of national territory in law amounts to the transfer of sovereignty over the said territory by the owner state in favor of another state. There can be no doubt that such cession is possible, and indeed history presents several examples of such transfer of sovereignty. It is true, as Oppenheim has observed, that hardship is involved in the fact that in all cases of cession, the inhabitants of the territory who remain lose their old citizenship and are handed over to a new sovereign, whether they like it or not. And he has pointed out that it may be possible to mitigate this hardship by stipulating an option to emigrate with such certain period in favor of the inhabitants of ceded territory as means of averting the charge of the inhabitants are handed over to new sovereign against their will. But though, from the human point of view, great hardship is inevitably involved in cession of territory by one country to another, there can be no doubt that a sovereign state can exercise its right to cede a part of its territory to a foreign state. This power, it may be added, is of course subject to limitations which the constitution of the state may either expressly or necessary implication impose in that behalf. In other words, the question as to how treaties can be made by sovereign state in regard to cession of national territory and how treaties can, when made, can be implemented would be governed by the provisions of the constitution. Stated broadly, the treaty-making power would have to be exercised in the manner contemplated by the constitution is subject to limitations imposed by it. Whether the treaty can be made implemented by ordinary legislation, constitutional amendment will naturally depend on the provisions of the constitution. Then kindly come to the next overleaf, my lords. Last few lines of this paragraph. We have already referred to Article 1(3)(c), and we have observed that it does not purport to confer power on India to acquire territories. It merely provides for and recognizes automatic absorption or assimilation into territory of territories which may be acquired by India by virtue of its inherent power as a sovereign state. So that 1(c) and 2, they are straightaway act of state. So even Constitution, my lord, can recognize by its provisions certain powers which are in the nature of act of state. It may circumscribe it or it may not circumscribe it. Now kindly also have 74 Santosh Gupta, my lords. This was read out by Mr. Nafre. But he said this is obiter. State of JK has no vestige. This is two judgment. State of JK has no vestige of sovereignty outside the Constitution of India and its own constitution, which is subordinate to the COI, Constitution of India. It is therefore wholly incorrect to describe it as being sovereign in the sense of its residents constituting a separate and distinct class for themselves. Residents of JK, we need to remind the High Court, are first and foremost citizens of India. Now, this is not obiter. I have explained in 75. My lords will look into that. There were direct questions in the High Court judgment. It was said, my lord, that JK is sovereign, and therefore their lordships dealt with it and said that that sovereignty is not there. It had lost its sovereignty. Then I have quoted the speeches, my lords, from Shri Nehru, my lords, and Dr. Ambedkar in para 76, 77, 78. Your lordship may just note, my lord, each of them are saying that, I may just read 76. Shri Jawaharlal Nehru said, we accepted it, and of course the accession was complete. It was not a kind of partial accession or limited accession. The accession was complete. But we said that we will abide by the verdict of the people whenever the chance or the opportunity comes. He also said, so Kashmir obviously is a constituent unit of the Federation of the Union of India. But a difference has arisen, subsequently arisen, you please remember that, not originally, between Kashmir and the other states, because subsequent to the earlier accession, the other states have become integrated more, which Kashmir was not and could not in the circumstances, as I have tried to point out. But nevertheless, it is a whole constituent unit of India. Various things flow from it, various consequences. Consequences, for instance, in regard to the President of the Republic, but the President's ultimate right has to remain for a constituent unit of India. So various consequences, I already spelled out on what follows from the integration and unionization. And Dr. Ambedkar also said, this has been read by the learned Solicitor General, Lordship just note. He explained what is meant by union. And kindly turn to next page, Manoj. I'm not relying so much. I've quoted Lord Rajaram Pal, which says destructible units and all. Maybe some lines need to be drawn. It can't mean that all the states disappear and federalism disappears. So that was your lordship's worry also when the learned solicitor was arguing about Article 3. Then para 80, the state of West Bengal versus Union. It expressly says that the feature of a compact or agreement between independent and sovereign units are absent in the Constitution of India. There is distribution of powers, but distribution of powers is not always an index of political sovereignty.
Where is this? Oh, yes, para 80.
I'm reading from what I have said, but this is part of the judgment. Para 25 I mentioned. The lordship may note that. In para 80. Then kindly have paragraph 51 going back a little. Para 51. That is PDF 293. Same written submission. Yes, Brother, I'm sorry, Brother. It's this para 25 of State of West Bengal is fully quoted, Brother, beginning at PDF 291. And your lordship will find the relevant portion in clause A. Okay. Kindly come to PDF 292. PDF 292. This is a paragraph 25. From fourth line, the result was a constitution which was not true to any tradition pattern of federation, there is no warrant for the assumption that the provinces were sovereign, autonomous units which had parted with such power as they considered reasonable or proper for enabling the central.
Where,
Page 291, PDF page
PDF 292.
291 it starts.
Yes, it starts in 291.
Can you see?
there is no warrant for the assumption?
Yes. There is no warrant for the assumption that provinces were sovereign, autonomous units which had parted with such power as they considered reasonable or proper for enabling the central government to function for common good. The legal theory of the constitution was the withdrawal of resumption of all powers of sovereignty into the people of this country and the distribution of these powers, save those withheld from both the union and the states by reason of provisions of part 3 between the union and the states. A truly federal form of government envisages a compact or agreement between the independent and sovereign states to surrender partially their authority in their common interest and vesting it in the union and retaining the residue of the authority in the constituent units. Ordinarily, each constituent unit has its separate constitution by which it is governed in all matters except those surrendered to the union. And the constitution of the union primarily operates upon the administration of the units. Our constitution was not the result of such compact or agreement. Units constituting a unitary state which are non-sovereign were transformed by abdication of power into a union. Then the second characteristics is supremacy of the constitution which cannot be altered except by the component units. Then see distribution of powers between union and regional units. If your lordship, the fourth is supreme authority of courts to interpret the constitution, that is D. Kindly come below that. In our constitution, characteristic D is to be found in full force. A and B are absent. There is undoubtedly distribution of powers between the union and the states in matter legislative and executive, but distribution of powers is not always an index of political sovereignty. So this theory, which bilateralism, compact and all this objective resolution was unilateral, adaptation was unilateral, Article 1 is unilateral, 370 is unilateral. So there is some exchange of thoughts and agreements to be within the fold of 370 does not make it bilateral. So bilateralism need not be introduced in 373. Kindly have para 51 next page. Even in a pre-constitution setting in Pramod Chandra Dev versus State of Odisha, para 17, a constitution bench of this court held that sovereignty of erstwhile ruler ends with cession of territory. And when this court said some sovereignty is retained after the execution of IOs, that was a passing reference as sovereignty was being discussed in the light of an old grant of land by ruler to son. Such grant would amount to law which was continued post 1948. So the rights under the said grant were recognized by the new sovereign power. And Indri Beruvari also takes the same view in para 31, which I had already read. So cession of territory is a very vital and Article 1 therefore declares the end of, and if any doubts remain, that's the last nail in the coffin of sovereignty. And it is surprising, Lord, that my friends on the right, Lord, wedded to democracy are seeking permanence based on a crown which is long gone. The king is dead, long live the king. The Lord should just note, Lord, in para 69, just even anger, Shri Anger also says that they are fully integrated. We can't extract some paragraphs here and there, Lord, and assert based on 2 paragraphs what is the meaning of our clause 1, 2, and 3. Page 26. If you shall come in that paragraph state at next page, that is 298, PDF 298. The draft Article 306A was placed before the Constituent Assembly on 1710 and passed on the same day. Dyanger said the meaning of accession is that at present day, the state JK unit is a unit of a federal state, that is Dominion of India. Dominion is getting transformed into a republic, which will be inaugurated on 26th. JK state therefore has to become a unit of the new Republic of India. He goes on to say that instruments of accession will be a thing of the past in the new constitution. The states have been integrated with the federal republic in such a manner that they do not have to exceed or execute a document of accession for the purpose of becoming units of the republic, but they are mentioned in the constitution itself. Now all this is left out and you extract 3 paragraphs where he is trying to say very lightly about referring to clause 1, 2 and 3. And he doesn't say what happens after the JK Constitution Assembly ceases. He could not have said, the times were so difficult. Therefore, it is a very brief speech. But these are much more vital expressions in his speech. You don't have to exceed or execute a document of accession for the purpose of becoming units. The preamble and the Article 1 and 5 and fundamental rights, all they complete. That's the republic. Without it, there is no republic. So, my lords, that's in my dispute submission, my lord. My submission with regard to this. I don't wish to, my lord, add anything about P56, etc., my lord, except to say that, not in Bommai's case, there are 2 observations with regard to the width of this suspending power. Paragraph 271 and 281. I'll give it in a piece of paper, my lords, the paragraphs without detaining your lordships. Six invocation will be in variety of situations which cannot be in variegated situations. So therefore, what will be the circumstances, emergency, provision, or will depend. So I just wanted to point out to supplement those paragraphs which I'll give. And one more thing, that's a Constitution Review Committee was constituted under the chairmanship of Venkat Chellaiah, my lords. And 356 was an issue whether it should be retained, or he said this is the bulwark of the Constitution. So the concept changes with time. Initially it was thought it will never be exercised, but the review committee says, and a very high level committee, Justice Jeevan Reddy was also a member of that committee. And they say that is a bulwark, but yes, there has been some abuse. Therefore, the checks and balances, the adjudicatory powers, the judicial review is there to check it. So with this, I will conclude and say, my lord, that let us bury 370. 35A, my lord, I'll just, my friend has filed a writ petition also questioning, my lord, 35A. So I just wanted to give, my lords, your lordship, which again I'll mention, my lord, in the piece of paper, the paragraphs of IR Kolho, where your lordships have held that this, if you come out with any instrument of law, constitutional amendment, which that was in the context of 31B, Vaman Rao and in Minerva Mill and all those were considered, and the lordships have held that all laws which are placed in 31B will be tested. And so far as certain, of course, prospective overruling, etc., is a different concept. But here we are finding that 35A has been super added. It's a complete lock, stock denial, a lot of several vital fundamental rights. So in view of IR Polo, I submit, my lord, that needs to be struck down. I'm grateful, my lord.
Thank you, Mr. Dev.
May it please your lordships. Lord, I beg to appear for the applicant in IA 139743 in writ petition 1070 of 2019.
Repeat that, Mr. Giri, the IA number?
Lord, the IA number is 139743. Lord, the All India Kashmiri Samaj
In
in writ petition number 1070 of 2019.
IA is filed which year?
Lord, the IA is 139743 of 2023.
23.
In writ petition number 1070 of 2019. But I'll just,
Yes,
Lord, areas which are covered, my Lord, by the learned attorney, the learned solicitor, and thereafter by Mr. Dwivedi, my Lord. Lord, I'll just say what has been covered, and therefore I don't have anything more to say on that. But my Lord, this is essentially my Lord, it's stressing on certain aspects, my Lord, which I think will be of assistance in making out a case before your lordships. My Lords, the instrument of accession, my Lord, is dated 27/10/1947. And that is at PDF 9 of Volume 1. My Lords, what happened in the thereafter, my Lords, in chronological order, I'll be obliged if your lordships kindly have a look at the proclamation issued by the Yuvraj Karan Singh in Volume 3 of the written submissions, the compilation of written submissions of the respondents at PDF page 44, part of the list of dates, my Lord, of the learned solicitor. Page 44.
Of volume?
My Lord, of Volume 3, the same volume which was being referred to by. Because clause 7 and 8 of the instrument of accession was being relied on to contend for the position that there was a vestige of sovereignty which was retained by the Yuvraj even then, even after signing the instrument of accession, because that is what is articulated in the instrument of accession as such. My Lord, on 25/11/1949, the draft constitution was ready. And therefore, my Lords, the Yuvraj Karan Singh had the entirety of the constitution, including 370 as it was incorporated in the constitution before. Article 1 and 370, my Lord, which is incorporated, which is made as part of the constitution, or which is made as part of the applicability of which was made as part of Article 370. All this was before him. And therefore, my Lord, on 25/11/1949, if your lordships have a look at PDF 44, Yuvraj Karan Singh issued my Lord, I'm reading from the solicitor's list of dates, issued a proclamation for the state of Jammu and Kashmir by which he declared and directed that the Constitution of India shortly to be adopted by the Constituent Assembly of India.
So, Giri, you are at PDF page 54.
No, PDF page 44.
44.
Written submissions, volume 3. My Lord,
Yes,
part of the
thanks.
list of dates that was placed before your lordships by the learned solicitor. My Lord, the document is also included, but I thought this is easier, my Lord, because your lordships will have to keep referring to it again and again. The said proclamation is both worth quoting in full. Sorry.
Yes, I get it. Yes.
Whereas with the inauguration of the new constitution for the whole of India now being framed by the Constituent Assembly of India, the Government of India Act 1935, which now governs the constitutional relationship between this state and the Dominion of India, will stand repealed. And whereas in the best interest of this state, which is closely linked with the rest of India by a community of interest in the economic, political, and other fields, it is desirable that the constitutional relationship established between the state and the Dominion of India should be continued as between the state and the contemplated Union of India, and the Constitution of India as drafted by the Constituent Assembly of India, which includes duly appointed representatives of the state, provides a suitable basis for doing so. I now hereby declare and direct that the Constitution of India, shortly to be adopted by the Constituent Assembly of India, shall, insofar as it is applicable to the state of Jammu and Kashmir, govern the constitutional relationship between this state and the contemplated Union of India, and shall be enforced in this state by me, my heirs and successors, in accordance with the tenor of its provisions, that the provisions of the said Constitution shall, as from the date of its commencement, supersede and abrogate all of the constitutional provisions inconsistent therewith which are at present in force in the state. Now, my lords, therefore, it was understood that on the enforcement of the Constitution of India, my lord, which took place on 26/1/1950, there is no residuary sovereignty that is retained, my lord, by the Yuvaraj in the state of Jammu and Kashmir. My lord, the territories comprised within the state are therefore mentioned in the Constitution. It is treated as a Part B state. The provisions of the Constitution are made applicable to the Union of India, including the state of Jammu and Kashmir, with effect from the date of enforcement, that is, my lord, on 26/1/1950, when the Constitution commences. It is, my lord, difficult to countenance an argument, my lord, this I say so with greatest respect, that there was any sovereignty which, whether you call it as residuary, internal, as distinguished from external sovereignty, which survives, my lords, the enforcement of the Constitution of India with effect from 26/1/1950, when, after, my lord, the Yuvaraj had also made it clear and had declared that the relationship between the state and the union will now be governed by the provisions of the Indian Constitution, which means that we don't have anything more. We are governed by the Constitution of India. We have also looked into it. There were 4 representatives from the state of Jammu and Kashmir earlier in the Constituent Assembly. We have gone through each clause, and we have ultimately looked at 370 also, which is an integral part of the Constitution, which is also a part of the Constitution. And we have therefore decided that we will abide by this. Now, my lords, the question of if this is the integration, therefore becomes complete, my lord, on enforcement of the Constitution, there is nothing residuary about. Now, if your lordships kindly have a look at, my lord, I am sorry, but then to make my submission, my lord, on the question of, my lord, what therefore survives under 3, what therefore survives, my lord, will also have to be looked into in Article 370 and 373, and there is nothing more, my lord, which can be read into it. There is nothing in the Constitution of India, my lord, which carves out an exception in the case of state of Jammu and Kashmir, both as regards the sovereignty, any sovereignty, other than, my lord, Article 370 itself. And 370, in my respectful submission, does not indicate that there is any residuary sovereignty that is left with the state of Jammu and Kashmir. It becomes a part of the Union of India. My lord, the enforcement of Article 370 also, and powers exercised by the President from time to time in issuing a constitutional order, is also an exercise of a power that is conferred, my lord, under the Constitution of India. It is nowhere else. President doesn't go outside the bounds of the Constitution. And therefore, my lord, if abrogation of 370, which would result, my lord, in the effacement of any special status that is given to the state of Jammu and Kashmir, is inbuilt into Article 370, and it is also within the knowledge of, my lord, the sovereign in the state of Jammu and Kashmir, my lord, prior to the enforcement of the Constitution, to say that I still retain some residuary sovereignty with me in spite of the enforcement of the Constitution after 26/1/1950, not reflected in Article 370, not reflected in any other provision of the Constitution of India, my lord, is not a submission that would be countenanced by your lordships. But what are the petitioners asking for? Petitioners, my lord, say that 370, which is a temporary provision, must be treated as a permanent part of the constitution. What for? If, my lords, is it for the purpose of, my lord, claiming for expansion of any right? Apparently not. No, my lord, because once the 370 goes, and, my lord, Jammu and Kashmir, my lord, therefore, the integration is complete even when the enforcement of the constitution takes place. My lord, the insignia of any sovereignty is a lawmaking power. One of the insignia is a lawmaking power. That's, my lord, the lawmaking power, my lord, has been with the union and with the states, my lord, in list 2 and list 3 also. Unless, my lord, the parliament by an overarching, resort to the provisions, my lord, of lawmaking power in the list 3 also supersedes the legislation that is prevailing in the state. If, my lord, it completely therefore applies after Article 370 is abrogated, isn't there an expansion of the right, my lord, that is available to any person who says that I am a resident in the state of Jammu and Kashmir? I therefore belong to that state. I also belong to the Union of India. But therefore, my lord, what is the abridgment of the right, my lord, that the petitioners are really concerned about? No, my lords, insofar as abrogation of 370 is concerned, when the lordships would have noted that sub-article 3 was also therefore part of, my lord, in the manner in which it was framed even before 1950. I mean, on 26/1/1950, my lord, this is how it looked at. And that was at a point of time when the Constituent Assembly for the state was yet to be convened. It was convened later, my lord, in January 1951. Now, if your lordships kindly come to that for a moment. There are two places, my lord, where the Constituent Assembly for the state is referred to. Firstly, my lord, in sub-article 2, but please come to sub-article 3. Notwithstanding anything in the foregoing provisions of this article, the President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such a notification. My lord, the crucial words are recommendation of the Constituent Assembly of the state referred to in clause 2. My lord, in clause 2, the reference to the Constituent Assembly is qualified by certain words, my lord. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in the second proviso to subclause D of that clause be given before the Constituent Assembly, my lord, please permit me to read it slowly. For the purpose of framing the constitution of the state is convened. Therefore, my lord, it was understood that a Constituent Assembly will be convened for the purpose of framing the Constitution of India as originally contemplated in Article 370 itself. But this Constituent Assembly is only for the purpose of framing the Constitution of the state. And, my lord, it is a fact which is accomplished that on framing the Constitution for the state, my lord, it dissolved itself. That it will be convened for a specific purpose and that it will dissolve itself were also matters within the knowledge of the framers of the Constitution even then. And then, my lord, therefore, in proviso, when they refer to the Constituent Assembly for the state, there was a terminus acto, my lord, for the Constituent Assembly, which was within the knowledge, my lord, of the framers, and therefore that is what is referred to in the proviso. My lord, it could not have been contemplated that the Constituent, or rather, my lord, let me put it this way. It was, my lord, it was concluded, or it was definitely, my lord, the intention that the Constituent Assembly for the state, which is convened for the purpose of framing the constitution of the state, will have a natural death, my lord, when the constitution for the state is framed. But when they say, my lord, that the recommendation of the Constituent Assembly for the state shall be necessary before the President issues such a notification, did they not have in mind that the recommendatory powers are therefore coterminous with the tenure of the Constituent Assembly, which has to end, my lord, with the framing of the Constitution for the state? It is not as if, my lord, the constitution contemplates a constituent assembly for any purpose other than the framing of the constitution for the state as such. Therefore, my lords, one of the termini which your lordships were referring to, there are two terminus echo, my lord, insofar as the Constituent Assembly is concerned, going by sub-article 2 and the proviso. One is the convening of the Constituent Assembly, and the other is the dissolution of the Constituent Assembly. The proviso merely does not say Constituent Assembly of the state. It says Constituent Assembly of the state referred to in clause 2. Clause 2 says Constituent Assembly for the purpose of framing the Constitution. Therefore, the tenure of the Constituent Assembly is inbuilt, my lord, into sub-article 2 and the proviso as well. If therefore, my lord, the triggering factor as per the proviso to Article 373 for the President to issue a public notification either abrogating it or, my lord, declaring that it will be operative only with such exceptions and modifications, is a recommendation of the Constituent Assembly of the state referred to in clause 2. It has to be inferred, in my respectful submission, that the triggering factor would be alive and operative only till such time as the Constituent Assembly is alive. And this is an inference, my lord, which I beg to infer and which I commend for your lordship's acceptance, is inbuilt into sub-article 2 and the proviso. That's why, my lord, the crucial words Constituent Assembly of the state referred to in clause 2 need not have been that way. But when sub-article 2 says before the Constituent Assembly for the purpose of framing the Constitution of India, therefore, my lord, even originally it was contemplated that this Constituent Assembly for the state will have no function other than, my lord, or will be functus officio once the Constituent Assembly of the Constitution of the state is convened. That, my lord, it's a historically recognized fact that it actually dissolved itself in 1957 itself. But that's a different matter. But the point is, my lord, for the purpose of the proviso, the triggering factor, my lord, is contemplated as being available coterminous with the life of the Constituent Assembly referred to in sub-article 2, and therefore, my lord, it ceases to have any significance, my lord, once the Constituent Assembly is dissolved and once the Constitution of the state is formed. But, my lord, it cannot, under any interpretative tool, give fodder to a submission that Article 370 as a whole, and at any rate Article 370 sub-article 3, would also cease to be operative once a proviso becomes inoperative. My lord, ideally, my lord, the proviso could have been deleted after the dissolution of the Constituent Assembly for the state. That's a different matter, my lord. One need not get into that hypothesis at all. But it cannot be contended that the power of the President vouchsafed under Article 373 would cease to be available because the proviso is no longer available to be operated upon. In my respectful submission, the proviso itself contemplates that the recommendatory power of the Constituent Assembly, my lord, whatever is the content of the recommendatory power or not, my lord, it's a different matter. I think enough submissions have been made on that. But the recommendatory power of the Constituent Assembly was intended even originally to be coterminous with the life of the Constituent Assembly, which anyway, my lord, was dissolved after the constitution of the state was convened. My lord, my written submissions are at pages 400 to 411, my lord, of volume 3. 401 to 411 of volume 3.
411 to
401 to 411. My lords. My lord, this aspect has been dealt with, my lord. I won't therefore take up more time of your lordships on this aspect. My lord, paragraphs 1 to 4 I have dealt with this. My lord, the next submission, my lord, would be on the aspect of federalism. My lord, there are two, my lord, papers, my lord, which your lordships may kindly have a look at, juxtaposed with each other. My lord, one is the opening remarks of Dr. Ambedkar, my lord, which your lordships will find in volume 8 of the compilation of documents.
Okay,
Sorry.
since you're beginning a new point on federalism, should we take it up on Monday?
Very well,
So that,
very well. My lord, I'll still maintain the timeline.
we are always conscious of how you are generally in the court, so we don't expect anything different. You'll be precise and always very,
grateful.
very focused. We
I'm
expect that as usual.
I'm grateful.
Thank you.
My lord, there was one request, my lord, lordship, if your lordships could consider, because it fell from your lordships, my lord, would it be possible for your lordships to convene at 10 o'clock on Monday so that we get 3 hours?
Lord, Mr. Nataraj had, my lord, 10 minutes of submissions. A new point.
There's circumstance for today, and we've given you full half day now.
Very good.
You've
Lord,
got a half day more.
No, Mr. Nataraj would like to have 10 minutes. And two young, two other, my lord, people who will, I know your lordships would not.
We'll come back.
All the young, not so young can divide the time period between 10:30 to 1.
10:31. At the same time, I know that everybody has worked very hard. We wouldn't want to
Therefore,
deprive
and
even
some
at
of
least
them
5
have-
minutes of time.
Lord,
to the
some
young
of them
people.
have worked since 10 years. Let them have, my lord, their day in the court, my lord,
You're
maybe
saying-
for some time.
I'm sure that the seniors who precede them will give them some time so that they have that
No,
time.
we'll
to
do
go.
that.
Certainly.
For example, my lord, Mr. Tanwani is also a research scholar.
Who?
Mr. Tanwani, Mr. Rahul Tanwani has been
Tanwani, Mr. Rajput, they have been working since many years.
Will certainly give
But
them.
whatever
some
they
time.
can contribute.
Told Mr. Tanwani that some of the points I wanted to make, I will keep for him.
I'm sure you'll be able to.
We'll do that.
It's a-
We'll do. We won't exceed the time. We'll finish by Monday, 1 o'clock or whatever is the time that your lordships are.
1 o'clock.
So we'll wrap it up on Monday for this side at 1 o'clock, and then in the afternoon we'll start the rejoinder.
Very good.
Grateful.
Grateful to you.
मुझे रिप्रेजेंटेशन करना है।
इसीलिए हम ये कह रहे हैं कि जो कमजोर है उससे इंसाफ होना ना, ताकतवर से इंसाफ की बात नहीं करेंगे आप, जो कमजोर है उसको उठाना पड़ेगा। और हकीकत है उत्तर प्रदेश में अगर आप सोशल, एजुकेशनल, इकोनॉमिक इंडिकेटर्स देखेंगे तो सबसे कम उत्तर प्रदेश के मुसलमानों के हैं। बिल्कुल सच है, ये तो गवर्नमेंट का डेटा कह रहा है, मैं नहीं कह रहा हूँ।
यूपी में ठाकुरवाद का वो चना फेंक रहे हैं कि आप लोग
दोनों
ठाकुरवाद की
बातों
वजह
का
से।
जवाब देता हूं। देखिए, जिन्ना का नाम हमने नहीं लिया था, अखिलेश जी ने लिया था। अयोध्या राइजिंग किताब सलमान खुर्शीद जी ने
लपका
लिखी,
किसने?
हमने नहीं लिखी।
लपका किसने जिन्ना को?
नहीं, लपका अब लीजिए, आप ये बात कहेंगे, लपकने की बात नहीं, उछाला किसने पहले ये तो बताइए ना। अब दूसरी बात मैं बताता हूं। इसके अलावा हिंदुत्व में भाषण राहुल गांधी ने दिया, हमने नहीं दिया। और इन्होंने सही कहा, ये नहीं बोलते हैं, कारण क्या है ना, ये तो साक्षात मूर्तिमान स्वरूप है ना, तो इन्हें बोलने की जरूरत नहीं है, ये तो करके दिखाते हैं। इसलिए मैं तो कहूंगा कि समाजवादी पार्टी इनकी भी टीम है, क्योंकि जो ये चाहते हैं, जो इनके दिल में है, वो लोग सिर्फ बोल के रह जाते हैं। हाँ, अब ये बात
कैसे
इन्होंने
इनके दिल में
जात की बात कही, तो मैं ये भी कहना चाहता हूं।
एक सेकंड, इनके दिल में जिन्ना है?
नहीं, ये तो मूर्तिमान स्वरूप है, साक्षात, इसमें कोई 19-20 नहीं है। अब दूसरी बात मैं कहता हूं, आपने जात की बात कही, देखिए यही मैं कहना चाहूंगा, एक बहुत अजीब बात है। जब हिंदू समाज की बात आए तो ब्राह्मण, ठाकुर, दलित, यादव, जाट, कुर्मी सब हो जाते हैं। भाई वहां क्यों नहीं होता? आप कभी बताइए कि ये शिया, ये सुन्नी, ये देवबंदी, ये बरेलवी, ये अहले हदीस, और ये तुर्क, ये बहना, ये गद्दी, ये घोसी, ये पसमंदा, ये तो नहीं होता है। यही तरीका है कि एक में तो जात दिखाते रहो और बाकी में, जबकि मैं एक और बात कहूंगा पूरे अदब के साथ, विद्वान आदमी है ये, एक मुसलमानों का फिरका बताएं जिसने दूसरे के खिलाफ फतवा ना जारी कर रखा हो कि एंटी इस्लामिक है, और दुनिया भर में, भारत में ही नहीं, दुनिया भर में लड़ाई एक दूसरे के खिलाफ ना लड़ रहे हो, मगर यहां पर सब मुत्ताहिद हो जाते हैं और हम लोग भी इसमें आ जाते हैं। हाँ साहब, सब एक है। जैसे मैं तो लखनऊ का रहने वाला हूं साहब, बचपन में मैंने हिंदू मुस्लिम दंगे नहीं देखे, शिया सुन्नी दंगे देखे थे, मगर ये चीज कहीं सामने नहीं आती है। इसलिए ये भी एक षड्यंत्र है कि हिंदू समाज को वर्ग, जाति और उसमें विभाजित करके रखिए, और अगर आप जातियों में विभाजित करें तो वो सोशली एक बड़ा अच्छा काम है।
प्रधानमंत्री का एक डायलॉग आपको याद दिलाऊं?
नहीं, मैं ये कह रहा हूं,
अभी जो नया मंत्रिमंडल विस्तार हुआ, प्रधानमंत्री ने खुद कहा कि हमने दलितों को जगह दी है, देखिए उनका सम्मान हम पार्लियामेंट में कर रहे थे, विपक्ष को स्वीकार नहीं है।
नहीं, मैं उसी पे आ
तो
रहा हूं।
आपने भी वही दाना डालना शुरू कर दिया है।
मगर जब आप सारी जातियों को साथ में लेके एक यूनिट, एक छत्र के नीचे आ जाए, वो
अजय मिश्रा टेनी आपके इतनी बड़ी मजबूरी क्यों बन गए हैं सर, बताइए? ब्राह्मण मंत्री बनाया, यही मजबूरी है ना? अब उनको हटाने में डर रहे हैं कि इकलौता बनाया था। क्यों पंडित जी, सही नहीं बोल रहे?
देखिए, जहां तक वो विषय कोर्ट में विचाराधीन है, तो वो तकनीकी आधार के ऊपर तय होगा, जो भी तय होगा उसके ऊपर हम लोग बात करेंगे। और जहां तक हम लोग जात की बात करते हैं, तो मैं तो ये कहना चाहूंगा, ये MY कॉम्बिनेशन क्या था ये बताइए? 4 जातियों को जूते मारने वाली किसकी वो थी? बिहार में भूरा बाल निकाल रहा हूं, भूरा बाल, 4 जातियों का नाम, अजगर, 4 जातियां खा जाएंगी, खाम, KHAM, ये सब जुमले किसके हैं? ये आज से 30-40 साल पहले से चला आ रहा है। जातियों में विभाजित करो और उसके बाद अपना उल्लू सीधा करो।
तेलगी के बारे में सुना है ना?
तेलगी खोटा सिक्का है,
तेलगी सांप है।
तेलगी बहुत स्मार्ट है।
तेलगी पूरी रिस्क लेगा।
मुझे तेलगी चाहिए।
क्या नाम था?
नहीं मैडम, है अब्दुल करीम तेलगी।
अगर देश की अर्थव्यवस्था कुबेर का खजाना है तो स्टैम्प पेपर उसकी चाबी।
जैसे आप कायदे की भाषा समझते हो ना, वैसे मैं फायदे की भाषा समझता हूँ। सेविंग्स अकाउंट में कॉन्फिडेंस जमा करा के रखा है मैंने, कैश भी आ जाएंगे।
मुबारक हो, बाप बन गए आप। स्टैम्प पेपर फायदा हुआ है।
जिस दिन आपने सामने वाले की जरूरत समझ ली, समझ लो आपने धंधा समझ लिया।
सरकार द्वारा अधिकृत स्टैम्प पेपर्स अपराधियों के हाथ में कैसे आ सकते हैं?
दिस इज ए स्कैम।
टोटल किया है
30,000 करोड़।
अरेस्ट अब्दुल करीम तेलगी नाउ।
अभी आप भी अपना आंकड़ा बोल दो।
3।
क्या आप कुछ बोले? क्या आवाज नहीं आ रही ठीक से?
3 लाख
भिजवाता हूँ। सब में और मेरे में बहुत फर्क है। मैं खिलाड़ी हूँ।
पिछले 6 सालों से हर रोज यही हो रहा है। मौसम, दिन, महीना, कोई भी हो, ना वक्त बदलता है ना लोग। घड़ी की सुई लेट हो सकती है, पर ये नहीं। इसे आप लगन, जुनून या फिर पागलपन भी कह सकते हैं, मगर हमारे लिए तो ये वो SIP है जो चौधरी साहब पिछले 6 सालों से हर दिन अपनी बेटी के लिए कर रहे हैं। जब जिंदगी जीने का तरीका ही SIP है, तो जिंदगी के लिए SIP क्यों ना हो। तो आज ही अपने फ्यूचर की शुरुआत SIP के साथ करें। जिंदगी के लिए SIP।
An investor education initiative by HDFC Mutual Fund। म्यूचुअल फंड निवेश बाजार के जोखिमों के अधीन है। योजना से जुड़े सभी दस्तावेजों को ध्यान से पढ़ें।
आप हिंदुओं को जातियों में बांटकर फायदा लेना चाहते हैं और मुस्लिम के जातियों की बात नहीं करते।
पहले तो मैं सुधांशु साहब से एक गुजारिश करूंगा कि आप अखिलेश यादव, राहुल गांधी एक जगह बैठ जाइए। अगर आप बोले तो इस होटल में रूम बुक करा देता हूँ। डिसाइड कर लीजिए कि मैं क्या हूँ। आप डिसाइड कर लीजिए, उसके बाद आप तमाम मिलकर एक साइन करके बोलिए ये हम सर्टिफाई कर रहे हैं, ये सर्टिफिकेट मैं अपने घर
पता है
में
उस कमरे में कौन सी कयामत आएगी ये सब